rise.
You may be seated. Senior counsel for the appellant, please.
May I please your lordships, my name is Charlotte Kenno and I am the senior counsel representing the appellant, Mr John Joe Stovall. My learned friend, Miss Holly Davenport Miller, will be acting as the junior counsel representing the appellant. Across the way we have Gregory Cook, who will appear as the senior counsel representing the respondent concerning the Secretary of State for Health, and Miss Lucy Barr, who will appear as the junior counsel for the respondent. My lord, there are two grounds of appeal in the instant case, and I shall be dealing with the first, that being whether the Secretary of State has acted intra vires, deciding to classify the Stove as an indoor venue for the purposes of the COVID-19 Vaccine Passport Act of 2021. And secondly, whether the Secretary of State's appeals process and decision to appoint Tom Jones as the administrator were procedurally intra vires. Would your lordships benefit from a brief summary of the facts of the case?
Please, counsel.
Thank you, my lord. Parliament passed the COVID-19 Vaccine Passport Act 2021 with the following provisions. There was Section 1, which states that the Secretary of State shall, by regulations made by the statutory instrument, provide the criteria for classification of whether the event will require COVID-19 vaccine passport status for attendees of an indoor event. There's also Section 3 that states that the Secretary of State must provide the organisers of events the ability to appeal any decision made under the regulations established under the power granted by Section 1. This states that the Secretary of State for Health issued COVID-19 passport regulations which read, indoor venues hosting events for over 1,000 attendees shall require attendees to demonstrate vaccine passport status. Mr Stovall, the owner of the Stove, wrote to the Secretary of State asking for whether his venue required attendees to demonstrate COVID vaccine passport status by the 2021 Act. However, Mr Stovall's venue is both indoor and outdoor, with 900 attendees normally inside the venue at one given time and 200 outside. The Department for Health decided to classify the venue as an indoor event and therefore require COVID-19 vaccine passport status. Mr Stovall sends another letter to the Secretary of State demanding that Section 3 of the COVID Vaccine Passport Act of 2021 and an appeal begins. All appeals were heard by Mr Tom Jones, who has a relation with the CEO of technology for the COVID vaccine passports. Mr Stovall applied for judicial review in regards to the state's decision and the fairness of the procedure. Mr Justice Miller agreed with the Secretary's decision, and it was intra vires, and appointing Mr Tom Jones as administrator was not biased. My lords, have you got a copy of my skeleton and bundle?
Yes.
Thank you, my lord. May I proceed with my submissions, my lord?
Please do.
Firstly, I will be submitting that the Secretary of State for Health has acted illegally due to the narrow ultra vires used in Attorney General against the Fulham Corporation in the year of 1921, Volume 1 of the Chancery Division, page 440. Because the decision maker must use the powers given to them correctly to interpret the law, and by doing so should not go beyond their statutory powers. Furthermore, I will be submitting that the Secretary of State has made an irrelevant consideration used in Roberts against Hopwood and others in the year of 1925 in the Appeal Court, page 578, when to considering the number of potential individuals in the venue at one given time. In making the decision maker must consider all relevant considerations and exclude all irrelevant considerations when making a decision. Lastly, I'll be submitting that in Porter against McGill in the year of 2001, Volume 2 of the Appeal Court, page 357, the Secretary of State has used improper power and improper purpose because, as a public authority, he must use his power correctly for the purpose of the Act. May I proceed with my first submission, my lords?
Please do, counsel.
Thank you, my lord. May I submit that the Respondent will argue that the Secretary of State has acted inter vires because he has used the statute and the policy for its purpose. However, it is clearly evidential to the courts that the Secretary of State for Health has acted ultra vires. I refer your lordships to the case of Attorney General against the Fulham Corporation in the year of 1921, Volume 1 of the Chancery Division, page 440. This can be found on tab 5 of my bundle, page 7.
Yes, counsel.
Thank you, my lord. Would your lordships benefit from the brief summary of the facts from this case?
No, thank you.
Thank you, my lord. In that case, may I direct your attention to tab 5 of my bundle, page 12, paragraph 24, and this is highlighted clearly for you in yellow with the sentence beginning with, "It is clear to me."
Yes.
Thank you, my lord. It is clear to me that what the council is doing is not only the carrying on of a business of a kind, but something which is the real point, which is not ancillary to or consequential upon that what is entitled to do under these Acts of Parliament. It has been conducted that what is being done is not a business or the carrying of a business, and cannot be regarded as such, because it has not been carried on at profit. It is clearly evidential that the Secretary of State for Health has acted ultra vires, as under the COVID-19 vaccine passport status and the Vaccine Passport Act found on tab 1 of my bundle, page 2, it states on section 1 that the Secretary of State shall, by regulations made by the statutory instrument, provide the criteria for classification of whether events require COVID-19 vaccine passports for attendees of an indoor event. Mr. John Doe Stables?
Counsel.
Yes, my lord.
Does the statute require that the 1,000 attendees be inside the venue at the same time? So if I'm thinking of a hypothetical here, imagine that I wished to open up a Santa's grotto and just myself and my assistant, my Alf, were in the grotto all morning, and then one by one 1,000 school children visited the grotto over the morning. Shouldn't I be required to get a COVID vaccine passport in that circumstance?
This doesn't fit the purpose of the Act. This is because over 1,000 attendees at one given period could be anywhere inside the venue. So that could then include toilets, or could include other venues in the rooms. So then where does the point stand? Not 1,000 attendees will be inside one place at one time, because otherwise we will not have a line to draw then, and it will not fit the purpose of the Act. There will always be a constant flow of people in and out different rooms, so this does not constitute as 1,000 people in a room at one given time. And the numbers itself are very low, with only 900 normally inside anyway. So that does not constitute and does not fit the purpose of the Act, and it therefore becomes meaningless.
Thank you, counsel.
Thank you, my lord. May I continue, my lord?
Please.
Furthermore, under the COVID-19 passport regulations of 2021, this can be found on tab 2 of my bundle, page 2, clause 1. It only states that indoor venues hosting attendees for over 1,000 attendees shall require attendees to demonstrate COVID vaccine passport status. Because of, like I mentioned, the vast outdoor space, Mr. Stovall's venue will not have over 1,000 attendees at one given time. Furthermore, the Act and the regulations both repeat that only indoor venues need attendees to demonstrate vaccine status. The Secretary of State has interpreted the law incorrectly and gone beyond his statutory powers by declaring the Stove as an indoor event. The Act does not specifically mention the requirement for COVID vaccine passport status for indoor and outdoor venues. In this case, if it did, if the Act mentioned indoor and outdoor venues, this would be granted correct. Therefore, may I proceed with my second submission, my lord?
Please do.
Can I just ask a question?
Yes, my lord.
Are you suggesting that the statute or the regulation takes precedence?
In terms of parliamentary sovereignty, the Act should always take precedent and therefore prevail any decision made by the Secretary of State, because Parliament has that power. And also the rule of law, which explained by Dicey, is that Parliament can make any law that it wants to, and therefore no one should override that. Furthermore, I submit that the Secretary of State has made an irrelevant consideration used in Roberts against Hopwood and others in the year of 1925 in the Appeal Court, page 578. When considering the number of potential individuals in the venue at one given time. In making a decision, the decision maker must consider all relevant considerations and exclude all irrelevant considerations when making a decision. Would your lordships benefit from the brief summary of the facts?
No, thank you, Counsel.
Thank you, my lords. My lords, may I turn your attention to tab 6 of my bundle, page 16, paragraph 14, highlighted in yellow again for you, starting with all the circumstances.
Yes, Counsel.
Thank you, my lords. All the circumstances relevant to the exercise of the discretion must be taken into consideration. Thus, we are demonstrating that all circumstances of considerations, meaning the outdoor space in Mr. John Joe Stovall, was not taken into consideration. If it was, the Secretary of State would have realised the statute specifically only mentioned status required for indoor events only attaining over 1,000 attendees. My lords, may I further guide you to page 19, paragraph 35, highlighted in yellow with "they took an arbitrary principle."
Yes, Counsel.
Thank you, Mum. They took arbitrary principle and fixed an arbitrary sum, which was not a real exercise of the discretion imposed upon them by the statute. Therefore, the Secretary of State has made an unfair and unjust decision towards Mr. Stovall's venue. This is because the Secretary of State has made an arbitrary decision not based on the statute or principle of the regulations of the COVID Vaccine Passport Act of the year 2021, but instead decided to perform an opposite action of what was imposed of him to do by the statute. He was only imposed to decline applicants for indoor venues containing over 1,000 attendees at one given time. Therefore, this is illegal. My lords, may I proceed with my third submission?
Please do, Counsel.
Thank you, Mum. I lastly submit that using Porter and McGill in the year of 2001, Volume 2 of the Appeal Court, page 357, that the Secretary of State has used improper purpose. This is because, as a public authority, he must use his power correctly for the purpose and the policy of the Act. Would your lordships benefit from the brief summary of the facts?
No, thank you, Counsel. And in the spirit of time, what would you define as the proper purpose of the Act? And what do you think is improper about the interpretation taken by the Secretary of State?
The proper purpose of the Act was to decline any venues that are small, indoors, with no other outdoor space. That is classified as an indoor venue and event, so that should only be taken into consideration when making these decisions. The only like I said, the purpose of the Act was to constitute for indoor events with 1,000 attendees. So anything that's got outdoor space, or the rooms, needs to be analysed properly and to fit the purpose of the Act, therefore meaning that outdoor spaces do not constitute as indoor places.
Thank you, Counsel.
Thank you, my lord.
Any further questions?
I was wondering, for outdoor spaces, if you interpret outdoor spaces as part of an indoor space as well, would you consider that to mean the Secretary of State expounding the law rather than expanding the law, if you understand what I mean?
So you mean that the law should be expanded into outdoor events? Is that what you're considering?
If you factor in outdoor event,
yeah,
as falling within the meaning of, what is an indoor event within this act, would you consider that to be expounding the law or expanding the law? If you're expounding the law, it means it should fall within the contemplation of the act.
Yeah.
And if you are expanding it, then it fits into your argument that the Secretary of State have acted ultra vires.
Yeah. So the law here is very narrow, including indoor events only. If the law was to say the outdoor and indoor events, then that would be expanding the law, and maybe the act needs to be changed to make that more specific, especially containing quite a large amount of attendees. That needs to be made into consideration. But I believe you're not expanding the law. You are following the act as the proper purpose of what it was meant to be, which is only for indoor events only. So either the act needs to be changed to make that relevant to outdoor events, like I said, the Secretary of State has decided to include outdoor venues as well as indoor venues into the same act, even though it does not state that. Thank you, my lords.
Thank you, counsel. Junior counsel for the appellant, please.
Thank you to my learned senior. My lords and lady, as Miss Keno has already announced, my name is Miss Holly Davenport Miller, and I shall be acting as junior counsel for the appellant, Mr. Stovell. As such, I shall be addressing the second point of appeal. That is, whether or not the Secretary of State's appeals process and decision to appoint Tom Jones as administrator was procedurally intra vires. My lords and lady, I shall be addressing this point of appeal under two submissions, as outlined within my skeleton argument. My lords and lady, are you familiar with my skeleton argument?
Yes, counsel.
Thank you, my lords and lady. My lords and lady, may I proceed with my first submission?
Please do.
Thank you. My lords and lady, the appellant submits that Mr. Justice Miller erred when holding that the Secretary of State's decision to appoint Tom Jones as the administrator for all appeals relating to Section 3 of the COVID Passport Act 2021 was not biased. As such, the appellant submits that the Secretary of State's decision to appoint Mr. Jones as the administrator for all appeals relating to Section 3 of the COVID Passport Act 2021 was in fact biased. Such submission will be firstly supported by the case of Porter and McGill 2002, which is reported at Volume 2 of the Appeals Cases Law Reports, page beginning 357. My lords and lady, would you benefit from a brief summary of the facts of this case?
Yes, please, counsel.
My lords and lady, the case of Porter and McGill related to the result of the local government elections in 1986, where there was a reduction in the Conservative Party from 26 to 4. In response to this reduction, leading members of the council considered how the council parties could be developed to advance the electoral prospects of the Conservative Party in the next local government election. Dame Shirley Porter, in being determined to have the Conservative win a greater majority in the next election, reorganised the party's administrative and decision-making structure, of which she chaired herself as the committee's chairman. This was not, however, a committee or subcommittee appointed by the council, but continued to develop policy, which included that of the designation of council-owned properties for sale in 1972. Under this policy, blocks of council dwellings were designated, and when a dwelling in a designated block became vacant, it was not relet but offered for sale to an approved applicant, with the intention that all the dwellings in the designated blocks become owner-occupied, therefore increasing the number of Conservative voters in each of the 8 key wards. The committee, in obtaining legal advice, made changes to the policy because they were informed that target sales in the manner they were planning to carry out would be unlawful. In response to this, the policy was revised to extend designated sales to 500 across the city, whilst maintaining the target of 250 sales in the marginal wards. In objecting to this policy, opposing councillors claimed that this policy prevented the council from meeting the statutory obligations as a housing authority and resultantly gave notice of objection to the auditor under Section 17 of the Local Government Finance Act 1982. The auditor found from his investigation that the council had had adopted a policy with the predominant purpose of achieving electoral advantage for the majority party, and that the committee were party to its adoption and implementation despite having knowledge that the policy was unlawful and caused such financial loss to the council. In response to this, the chairman of the Housing Committee, Dame Shirley Porter, appealed the auditor's conclusion to the Divisional Court. However, this court dismissed their appeals. The Housing Committee then appealed to the Court of Appeal, which held by majority, since they had acted on what they believed to be legal advice, they were not guilty of willful misconduct. The House of Lords finally held that the auditor's conduct, when seen in the context of the investigation, was not bias. My lords and lady, was the summary facts of that case sufficient?
More than.
Thank you, my lords and lady. My lords and lady, may I proceed with my first submission?
Please do.
Within the case of Porter and McGill, Lord Hope of Craigshead stated that, at page 494 of the law report, which can be found at tab A, page 99 of my bundle, that the sentence beginning, the question is...
Yes, counsel.
Thank you, my lord. The question is whether the fair-minded and informed observer, having considered the facts, would conclude that there was a real possibility that the tribunal was biased. Therefore, my lords and lady, the test which must be satisfied for determining whether or not procedural impropriety has occurred via bias consists that where a fair-minded and informed observer, having considered the facts of the case before them, can conclude that there is a real possibility that there has been bias. And so, the court today should apply this test. Specifically, it should be considered whether the fair-minded and informed observer, having considered the facts, would conclude that there is a real possibility that there was bias in Mr. Jones's decision to deny Mr. Stovell's appeal. This being so, counsel for the appellant submits that such an observer would conclude that there is a real possibility that Mr. Jones's decision was based upon bias. This is because Mr. Jones's wife, Roxy Jones, is the owner and CEO of the company providing the technology and support for COVID vaccine passports. It is important to remember that, in Mr. Stovell's appeal being rejected, his venue is subsequently classified as an indoor venue hosting events for over 1,000 attendees, which results in his venue requiring attendees to demonstrate COVID vaccine passport status. As a result, Mr. Stovell is going to have to use the COVID vaccine passport technology and support services. As I am sure is clear, my lords and lady, in Mr. Stovell's appeal being rejected, the company providing the COVID vaccine passport technology and support services just so happens to gain an additional customer, likely increasing the company's revenue and without little doubt increasing its operative success. Of course, in Mr. Jones being the owner and Mrs. Jones, I apologise, my lords and lady, being the owner and CEO of this company, she will more than likely reap the benefits of this increased revenue and operative success.
Counsel for the Secretary of State are likely to try and convince this Court of Appeal that the current test that you've outlined there from Porter and McGill of assumption of bias, presumed bias, is too burdensome on the government, and that going forward we should redraw that test to make it a test whereby we must evidence bias in order to find a decision biased. Why, in your opinion, can you submit that the court shouldn't heed this advice and depart from the Porter and McGill test?
My lords and lady, the appellant would submit that in restricting the test for bias to proving that there has been bias would be an impossible task. Bias is can very much be a thought process, and so to prove someone's thoughts or way of thinking would be very difficult. By extending the test, as in Porter and McGill, to the presumption of bias, you can only at that point be able to pursue there being bias, I guess, and hence why the case of Porter and McGill and the test within it should be followed.
Why do you think that bias is wrong or should be avoided in government administration?
If, my lords and lady, if bias was accepted within governmental processes, you would have a very unfair system which would be contrary to the rule of law, whereby no individual is above the law. If governmental individuals are then able to, say, for example, with the recent COVID pandemic, issue business to those who make masks because they are friends with them, then they are using the law in their favour and therefore putting themselves above the law. So it creates a very unfair and unjust legal system within the United Kingdom. Thank you, my lord. My lords and lady, would you like me to continue with my first submission?
You can move on to your second now.
Thank you, my lord. My lords and lady, the appellant secondly submits that Mr. Justice Miller was incorrect to hold that the Secretary of State's decision to conduct appeals as brought under Section 3 of the COVID-19 Vaccine Passport Act 2021 by considering only papers was within Mr. Jones's and thus the Secretary of State's discretion. This being so, the appellant submits that the Secretary of State's decision to conduct appeals as brought under Section 3 of the COVID-19 Vaccine Passport Act 2021 by considering only papers was not within Mr. Jones's and thus the Secretary of State's discretion, and as such the Secretary of State acted procedurally improper and ultra vires, and their dismissal of Mr. Stovell's appeal should be disregarded. The appellant submits this by relying upon the following two cases, the first of which is Ridge and Baldwin and others 1963, which is reported in Volume 2 of the Weekly Law Reports, page beginning 935. My lords and lady, would you benefit from a brief summary of the facts of this case?
No, thank you, counsel.
Thank you, my lord. May I proceed with my submission?
Can I just ask a question, please, counsel? Which is it you're suggesting? Which part of the appeal is mandatory and which is directory?
My lady, if I may take a moment. My lady, the appellant submits that the process of considering appeals was I apologise, my lady.
Essentially, counsel, what are you submitting that it was mandated that the Secretary of State do that they didn't do in this particular appeal?
The appellant submits that the Secretary of State should have conducted an appeal by way of oral hearing, whereby Mr. Stovell's appeal would be heard, essentially, rather than just via papers.
Fantastic. And I guess what would be your reason as to why you think this case is important enough to require an oral appeal? So what, in your opinion, makes this particularly necessary?
I guess given the appellant submits that within this specific case, given that the appellant's appeal was via papers, they were not adequately able to have their opinion on why their appeal should be accepted heard through submitting papers. The only real way that they could have done that was through an oral hearing where their opinions could be heard by submitting papers. It's simply facts and Mr. Jones could consider, and so as stated, an oral hearing would have allowed his opinion to be heard and possibly a different decision to be made. It was the only way that a fair outcome could be come to.
Thank you, counsel. You make it.
Thank you, my lord. As stated, the appellant submits this point of appeal in following the case of Ridge and Baldwin and others. My lords and lady, would you require a brief summary of the facts of this case?
No, thank you, counsel.
Thank you, my lord. Within this case, Lord Morris of Borthwick Jest, at page 113 to 114 of the law report, tab B, page 144 of the bundle.
Yes, counsel.
Thank you, my lord. Stated, sentence beginning, it is well established.
Yes.
It is well established that the essential requirements of natural justice at least include that before someone is condemned, he is to have an opportunity of defending himself, and in order that he may do so, that he is to be made aware of the charges or allegations or suggestions which he has to meet. See Canada and Government of Malaya. My lords, here is something which is basic to our system. The importance of upholding it far transcends the significance of any particular case. Just prior to making this statement, Lord Morris of Borthwick Jest stated at page 113 of the law report, at page 142 of the bundle, sentence beginning, they gave him no opportunity.
Yes.
Thank you, my lord. They gave him no opportunity to defend himself or to be heard. The second case to which the appellant relies on is that of the King and the Chancellor, Masters and Scholars of the University of Cambridge, otherwise known as the Bentley's case, 1722, as reported in volume 93 of the All England Law Reports, page beginning 698. My lords and lady, should you require a brief summary of the facts of this case?
No, counsel, and in the interest of time, if you want to summarise your last point.
Of course, my lord. In summary, my lord and lords and lady, the appellant submits that the Secretary of State's decision to conduct appeals as brought under Section 3 of the COVID Vaccine Passport Act by only considering papers and not allowing Mr. Stovall to adequately be heard as in accordance with the authorities of the case of Ridge and Baldwin and others, and that of the King and the Chancellor, Masters and Scholars of the University of Cambridge, nor the opportunity to defend himself, was not within Mr. Jones's and thus the Secretary of State's discretion when applying the principle of natural justice laid down in Ridge and Baldwin and others, and the Bentley case, and as such the Secretary of State's acted ultra vires and their dismissal of Mr. Stovall's appeal should be disregarded. My lords and lady, if you should so agree with this submission and or the appellant's first submission, counsel for the appellant submits that you must allow Mr. Stovall's appeal and the decision of Mr. Justice Miller should be disregarded.
Thank you, counsel.
Thank you, my lords and lady.
Senior counsel for the respondent, please.
My lords and ladies, as you have heard, my name is Gregory Cook and I'm the senior respondent for the Secretary of State. May I give you a brief summation of my three submissions?
Please do, counsel.
Thank you, my lord. My first submission is that Attorney General and Fulham Corporation demonstrates when an ultra vires act is and how the Secretary of State is acting within his scope of powers when deciding the Stove is an indoor venue. Secondly, the Secretary of State, when considering the potential capacity of the indoor venue, was making a relevant consideration as per Tesco Stores Limited and Secretary of State for the Environment and others. Furthermore, the decision of the Secretary of State to include the outdoor attendees as potential indoor attendees does not breach the Wednesbury unreasonable standard laid out in Associated Provincial Pictures Houses Limited and the Wednesbury Corporation. Finally, the Secretary of State for Health has not fettered his discretion as shown in the case of British Oxygen Co Limited, Appellants, and the Ministry of Technology, Respondent. The Secretary of State has listened to the appeals and referred it to the relevant authorities. Furthermore, Padfields and others appellants, and the Minister of Agriculture, Fisheries and Food and others, demonstrates that discretion is not unlimited when the decision does not promote the policy of the Act. The Secretary of State for Health has promoted the policy in his decision in allowing Mr. Stovall's appeal. Do my lord and ladies have a copy of the bundle and the skeleton?
Yes, counsel.
May I proceed with my first submission?
Please do.
Thank you, my lord. My first submission is that the Attorney General and Fulham Corporation demonstrates when an ultra-vires act occurs and how the Secretary of State is acting within his scope of powers when deciding that the stove is an indoor venue.
Counsel, the appellants made the argument that the proper purpose of this act was to regulate indoor venues, and thus the stove should fall outside of our regulations because it has an outdoor component. If you were to reformulate the proper purpose of this act, how would you reformulate it?
Is my lord asking me for what I think the proper purpose of the act should be?
Yes, please.
Okay. I believe the proper purpose of the act is if at any point there is a venue that is indoor and has over 1,000 people, that should require the COVID passport. That is, I believe, the purpose of the act.
So how would you deal with the Santa Claus hypothetical that I set the appellants earlier?
My lord, I would deem it as if it's only 1,000 people in a venue at one time, one specific time. In your scenario, there would only be a matter of 3 or 4 people in the venue at once. That to me seems...
But isn't the appellant contending here that this has a capacity of 900 and therefore would fall under that threshold also?
The venue has a potential capacity of 1,100. So that's how many people could be indoors and outdoors, but there's no saying where those 1,100 people would be at any time. All 1,100 could be indoors, all 1,100 could be outdoors. And as he states in the question, Mr. Stovall, it is only normally that there's 900 people indoors.
If the counsel for the appellant was able to satisfy the court that only ever one time 900 are indoors and 200 were always outdoors and they were marshalled in and out under the 1,000, would that satisfy the Secretary of State?
I believe so, yes.
Okay.
However, no such guarantees could be made.
Thank you.
I would refer the court to my bundle, tab 1. Has my lord found that?
Yes.
And if my lords and ladies could go to page 7 and to the paragraph beginning, however, this is not the real point.
Yes.
Thank you, my lord. The Fulham Corporation case states, however, that is not the real point on which the matter turns. The matter turns on this, whether or not the council has either expressly or impliedly the power to conduct the operation which it is conducting. We can see in this case that the Secretary of State clearly has said powers as they were bestowed upon him in the COVID-19 Vaccine Passports Act. He has acted well within his scope of powers, so at all times he was acting intra-vires, not ultra-vires. May I proceed to my second submission?
Please do.
Thank you, my lord. My second submission is that the Secretary of State, when considering the potential capacity of the indoor venue, was making a relevant consideration as per Tesco Stores Limited and the Secretary of State for the Environment and others. If I could refer you to the case I've just mentioned, tab 2, has my lord found that?
Yes.
And if my lords and ladies could turn to page 17 of the tab 2.
Yes.
And have my lords and ladies found the paragraph beginning, but it is entirely?
Yes.
Thank you. It states as such, but it is entirely for the decision maker to attribute to the relevant considerations such weight as he thinks fit. And the courts will not interfere unless he has acted unreasonably in the Wednesbury sense. My lords, as you can see, he has taken such relevant considerations. He has considered the capacity of the indoor venue, the potential capacity. And that is all that matters for this case. The potential numbers of people that could be inside spreading COVID. It is the absolute detriment to not consider this venue as indoor, as there's a high chance there'll be over 1,000 people inside the venue, in the indoor section of the venue at any time, and there is no guarantees that the John Joe Stovall has made as to any other state of affairs. Furthermore, the decision of the Secretary of State to include the outdoor attendees as potential indoor attendees does not breach the Wednesbury Unreasonable Standard, laid out in the Associated Provincial Pictures Houses Limited and Wednesbury Corporation. If I could refer my lords to tab 2,
Yes.
to page 7. Apologies, my lord. Apologies, sorry. If I could refer to the quote I had already made, I believe that sums up that summation. May I proceed to my third submission?
Can I just ask one question there, please, counsel? When would something be unreasonable in law? What is the test we're looking at?
That'd be the unreasonable test. And in that, so it'd be whether any other peer would take the same course of action, then it would not be deemed unreasonable. So
It's quite a beneficial test for you, isn't it?
yes, but that is the law.
Okay.
So it simply states that if anybody in the similar position would make the same decision, no matter how ludicrous the decision, it cannot be deemed unreasonable. And I believe in a situation such as this, to deem an indoor venue that could potentially have over 1,000 people inside it as an indoor venue with potentially 1,000 people inside it, I don't think that would be deemed as ridiculous. I think another similar peer would make the exact same decision. Therefore, I do not believe it breaches the unreasonable principle.
Okay, thank you.
May it please the lords and ladies, I'll continue to my third submission.
Please do, counsel.
My third submission is that the Secretary of State for Health has not fettered his discretion, as shown in the case of British Oxygen Co Limited, Appellants, and the Ministry of Technology, Respondent. The Secretary of State has listened to the appeal and referred it to the relevant authority. If I could refer you to the case of British Oxygen Co Limited Appellants and the Minister of Technology, Respondent, found on tab 5. Has my lords and ladies found that?
Yes, counsel.
Page 47, and the paragraph beginning, I see nothing wrong with that.
Yes.
Thank you, my lords. It states, there may be cases where an officer or authority ought to listen to a substantial argument reasonably presented urging a change of policy. What the authority must not do is to refuse to listen to it at all. There is no expected outcome. The appeal should be heard and should be agreed with. It merely has to be acknowledged. It has to be...
At what point would you have conceded that? As in, at what point would you have gone, yes, we didn't listen here?
That would be if the Secretary of State... Sorry, my lords, might I have a moment to
Yeah,
brief my
definitely.
notes? Sorry, my lord. I would refer to it, the fact that the Secretary of State granted the request for an appeal would be that drawing line in the sand. If he had rejected the request for an appeal, that would be in breach of the discretion. However, he doesn't. He grants the request for an appeal, and then that request is turned down by the relevant authorities. There doesn't need to be an appeal if it's not deemed necessary. However, there has been...
So you're saying the line in the sand is the moment he sends it off to Mr. Jones?
Yeah, who then, the relevant authority, who then says it's not worthy of an appeal.
Thank you.
It would be too burdensome on the government if every single appeal had to go through the entire process, no matter how fanciful or not based in law they are.
Okay, thank you.
Thank you, my lord. If I might continue with my submission, I would further argue that Padfield and others, appellants, and the Minister of Agriculture, Fisheries and Food shows that discretion is not unlimited when the decision does not promote the policy of the Act. Apologies, my lord. However, the Secretary of State for Health has promoted the policy in his decisions and in allowing Mr. Stovall's appeal. If I could refer you to tab 6 of the bundle.
Yes, counsel.
And to page 72. Thank you, my lord. The final paragraph on the page. And the sentence states, Parliament must have conferred the discretion with the intention that it should be used to promote the policy and the objects of the Act. The policy and the objects of the Act must be determined by construing the Act as a whole, and construction is always a matter for the law of the court. As we can see, discretion is not unlimited. However, discretion is allowed when it's to promote the policy of the Act. I would argue that the policy of the Act is to protect the health of the patrons of Mr. John Joe Stovall's venue. It is to stop the spread of coronavirus, and this is being achieved by ensuring everyone has to have the COVID passport. It is being achieved in ensuring that this is an indoor venue and has the adequate protections that an indoor venue requires. Do my lord and ladies have any questions?
No, your time is now expired, counsel. Any more questions at all? No? Thank you. Junior counsel for the respondent, please.
My lords and lady, my name is Lucy Barr and I am the junior respondent for the Secretary of State, and I will be discussing why the decision by Mr. Justice Miller against Mr. Stovall was decided correctly. There has been no procedural impropriety, and the Secretary of State acted inter vires throughout the process of conducting appeals and appointing Tom Jones. The first of my two submissions is that the Secretary of State did not act procedurally ultra vires with respect to Section 3 of the COVID-19 Vaccine Passport Act, as an appeal was granted to Mr. Stovall, and the statutory requirement of Section 3 of the Act has been fulfilled, as per the Crown and Secretary of State for Home Department ex parte JFM. My second submission is that Mr. Justice Miller was correct in the decision to reject the notion that the Secretary of State's decision to appoint Tom Jones as administrator was biased. This is because when applying the test set out in Porter and McGill, it is much too easy to demonstrate bias. Can I confirm you have my skeleton argument and my bundle?
Yes, counsel.
Then, my lord, may I proceed with my first submission?
Please do.
The Secretary of State did not act procedurally ultra vires with respect to Section 3 of the COVID-19 Vaccine Passport Act. Section 3 is a statutory provision of the Act outlining the procedure to provide the organiser of the event the ability to appeal any decision made under the regulations. The mandatory provision in Section 3 has been satisfied, thus there is no case for Mr. Stovall to appeal the decision of the Secretary of State. There is no suggestion in the Act that the appeal is required to be done in person. There has been substantial compliance as per the three-stage test that Lord Wolfe suggested in the Crown and Secretary of State for Home Department. My lord, do you require the facts of this case?
No, before you continue though, counsel, could you explain what you mean by a mandatory provision and what you mean by that?
A mandatory provision is what the Act has actually set out. They have named what has to be done, and this has to be done in order to make sure that what they've set out is being done.
And how does that differ from a directory provision?
A directory provision is simply what this situation may look like. So in this example, the directory provision would be what the hearing would look like. For example, an oral appeal, as they have suggested. The statute doesn't explain actually what is meant, so it's not mandatory, it's simply directory.
So what does that mean for your client?
This means for my client that the statute doesn't explain what is meant by the appeal. It doesn't need to be done in any particular way. We cannot impose burdens on ministers and departments to go beyond the statute. If it doesn't say it needs to be done orally, then it doesn't. If Parliament wanted the appeal done in person, they would have explained this, and it shouldn't be for the court to add extra red tape to this scenario.
Thank you, counsel.
If I can refer your attention to page 8 of my bundle, line beginning, is the statutory requirement fulfilled?
Yes.
1. Is the statutory requirement fulfilled if there has been substantial compliance with the requirement, and if so, has there been substantial compliance in the case in issue even though there has not been strict compliance? 2. Is the non-compliance capable of being waived, and if so, has it or can it, and should it be waived in this particular case? 3. If it is not capable of being waived or is not waived, then what is the consequence of the non-compliance? When applying this test to the case at hand, we can see that there has been substantial compliance with the requirements of Section 3 to allow an appeal, as the appeal was granted and completed. The suggestion by Mrs. Savell that the appeal should be delivered orally is easily capable of being waived, and subsequently was waived. Finally, the consequence of the appeal not being in person is very minimal, and would not likely provide a different result for Mr. Savell. There are no extra facts of the case that Mr. Savell could provide orally that he could not provide through papers. The case at hand can also be distinguished from Bradbury and Enfield London Borough Council. Clearly, as no notices at all were served in this case, as there was no substantial compliance, whereas in this case the Secretary of State clearly complied with Section 3 and did allow for an appeal to happen, thus there was substantial compliance.
Counsel, can I just stop you there and ask, when is it then that an oral hearing would be necessary? In what sort of circumstances?
I think if it was named in the Act that an oral appeal needs to be completed, then they would have to complete an oral appeal.
So your only consideration of an oral appeal is whether Parliament demanded one or didn't?
I think an oral appeal can be helpful in different cases, but it's not on the courts to impose an oral appeal. A case that should be applied, however, is Coney and Choice. My Lord, do you require the facts of this case?
Yes, please.
In Coney and Choice 1975, Roman Catholic schools in the north of Nottinghamshire proposed to go comprehensive. Around 300 parents sent a petition against the proposed reorganisation to the Secretary of State, but the scheme was approved. The parents sought declarations and injunctions to prevent the reorganisation on the grounds that the notices of the scheme had not been posted at or near a main entrance of the two schools. Regulations made under the Education Act 1944 are directory, not mandatory. A minor failure to comply with the regulations would not render the Secretary of State's approval void. An appeal would be refused, since the objects of Section 31 had been achieved.
Counsel, how would you distinguish that from the Bradbury case?
If I could just have a moment to consult my notes. In the Bradbury case, no notice was given at all, whereas in Coney and Choice, there was notice, it was just not put where they felt that they would be able to see it.
Thank you.
When applying the case in question, the object of Section 3 has been achieved. This was simply to allow for organisers of events like Mr. Savell the ability to appeal any decision. Mr. Savell was granted an appeal and it was denied. Any technicalities the appellants would like to present are simply technical defects that should not be allowed to hinder Parliament's intention. Through this Act, Parliament intended to make venues safer and allow for the Secretary of State to provide criteria for the classification. I submit that the merits of Section 3 were satisfied, and thus the Secretary of State did not act procedurally ultra vires. He was simply implementing the Act. This concludes my first submission. Do you have any further questions?
No, thank you, counsel.
My Lord, may I proceed with my second submission?
Please do.
Mr. Justice Miller was correct in the decision to reject the notion that the Secretary of State's decision to appoint Tom Jones as administrator was biased. This is because the mere connection of marriage between Tom Jones and Roxy Jones is insufficient to demonstrate bias, and a presumption of bias should not be enough for the Secretary of State's decision to be judicially reviewed. When applying the test set out in Porter and McGill, it is much too easy to demonstrate bias. The judge, in this case, has extended the idea of bias much too far, and it should be reconsidered what it means to be biased in law. My Lord, do you require the facts of this case?
No, counsel. I guess before you continue with your submission, the junior counsel for the appellant made several arguments against this. Would you be able to summarise where you think she was wrong, why counsel was wrong?
I think she was wrong because obviously normally you should follow judicial precedents and what has been set before you. However, when there is instances that the court can see that there will be an injustice made, this should be set aside in order to correct the law. So this is one of those occasions.
And if I may, there's actually a very specific aspect of the submission of the junior counsel for the appellant that I consider to be very crucial. And that's the, fair-minded and informed observer test for people determining what constitutes a biased behavior. I really want to hear your specific response to this point, and if you think that the test of fair-mindedness and informed observer in the context of this case should be subjective or objective.
I think the test in general is too wide. I think there should be an ability to have to prove bias, because in any case you could say every single person has an inherent bias. Me, you, everyone, especially to do with an issue as widespread as coronavirus. And I think any single person could constitute bias, so you need to be able to prove this rather than simply assume it.
Okay.
Continue.
If I can refer your attention to page 143 of my bundle for the test line beginning whether the fair-minded.
Yes.
Whether the fair-minded and informed observer, having considered the facts, would conclude that there was a real possibility that the tribunal was biased. This means that English law as it stands only requires a presumption of bias to be found. The test should no longer be a presumption. It has become too easily to satisfy, meaning many people rely on it upon judicial review. This is specifically important when applying this to the facts of the case, as with an issue as widespread as vaccines and coronavirus, most people or someone they are close with, as Tom Jones is with his wife, have a specific opinion or viewpoint that could be construed in some way as a real possibility of bias. The pandemic has affected such a huge amount of people that virtually no one would have a completely unbiased opinion. The test for bias needs to be requiring proof when the decision of judges is surrounding such a serious topic such as appeals, judicial review. Simply a presumption should not be enough to cause a decision to be made void. Tom Jones himself does not have an affiliation with the company, and there is nothing in the facts.
Sorry, can I stop you there? Surely the point of a presumption is that it's rebuttable, and therefore it places the onus on the other party, the party with the best knowledge, to bring evidence that there was no bias.
I agree, but I think there is no way to evidence I don't have this bias. There's no way to prove your thoughts. There's no way to show that he didn't have any specific conversation with his wife. I think in this scenario, the test needs to be further than just trying to prove that you didn't have those thoughts or those conversations.
Do you think it's more plausible then that the other party should be required to prove actual bias if the person saying that he isn't biased can't be expected to?
Yeah, I think the other party needs to be able to bring about some sort of proof, whether it is proof of a conversation, some sort of documents that can prove that it's further than just a conversation or a thought process.
So would the consequence of this test be that the standard position is to assume that government is not biased until somebody comes forth with evidence of bias?
I think so, because I think, as I said before, that everyone has some sort of inherent bias. There's nothing to say that every single person is completely a blank canvas, and I think everyone's personal experiences bring about some sort of bias, so we can't just rely on that, otherwise you could judicially review most decisions through this way.
And that takes me back to the previous point I was making about whether that test should be objective or subjective. So it does appear you are suggesting it should be subjective. So in other words, there are no defined criteria for, defining what constitutes, act of biasness in any case. Not even in this case.
I think it needs to be quite a wide test as it is, but just slightly less wide now. I think there needs to be no evidence at the moment, whereas I think it's just slightly moving the test. There needs to be evidence, but it doesn't have to be anything in particular. Obviously, every case is different, and bias can come from anywhere, but I think there needs to be something further than a thought process or a conversation.
Okay.
Making the test for bias so easy to satisfy encourages judicial review to increase. This is a long process for a reason. Parliament is sovereign and their decisions should not be questioned without proper proof and reasoning, not simply the possibility of bias. The ease of presuming bias undermines the stages, process and role of judicial review as well as the rule of law. My Lord, I submit that the spirit of the law and the objectives of the COVID-19 Vaccine Passport Act should not be dampened by Mr. Stovall trying to find a loophole of blaming presumed bias for a decision he does not agree with. This concludes my final submission. Do you have any questions?
No, thank you, counsel. Thank you, counsel, for your submissions. The decision of the judicial panel today on a judgment of 3-0 is that the substantive arguments made eloquently by both sides are irrelevant due to the fact that the decision of the Secretary of State to ask Mr. Tom Jones to consider this case was on the presumption of bias outlined in Porter against McGill evident to us. It is an essential purpose of English administrative law that justice must not only be done, but justice must be seen to be done. And in these instances, the outlined arguments by the junior counsel for the appellant as to why Mr. Tom Jones might be perceived to be biased we find compelling, and consequently we order the Secretary of State to assign the appeal to an individual who will not be presumed to be biased. If Mr. John Joe Stovall is still not happy with the outcome, we will bring that case back to the courts to rehear on the substantive merits at a later date. That concludes our judgment. Thank you, counsel.